As the election season heats up and we see more mobilization by extremist groups at public protests and elsewhere, it's important to remember that the First Amendment does not protect certain categories of extremely dangerous speech, such as incitement to violence or lawlessness. Another category of extremely dangerous, unprotected speech are true threats. These are statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. The Supreme Court has held that these threats alone can harm the intended victims. So, how can law enforcement evaluate whether statements are indeed true threats? True threats must convey a serious expression of intent to harm, and cannot be jests, hyperbole, or other statements that, taken in context, do not suggest a possibility of real violence. In a recent opinion, the Supreme Court stated that prosecutors must show that a speaker needs to know that their statements could be seen as threats and recklessly deliver them anyway. With all this in mind, law enforcement must consider the specificity of the threat and its full context to assess its seriousness and distinguish it from protected speech. Courts have held that true threats can be implicit as well as explicit threats, and that they can also involve non-physical injury, such as targeted messages that threaten immigration, economic, or legal consequences in order to deter people from voting. Symbolic speech, like cross-burning, can also be a true threat if done to intimidate others. Officials generally cannot preemptively silence speakers or cancel events in order to prevent threats of violence. That is considered a prior restraint forbidden under the First Amendment. Still, there are many content-neutral time, place, and manner restrictions that officials can consider in order to mitigate the risk that threatening speech will result in violence. Please refer to ICAP's guidance for more information.